This video on the divorce and legal separation process in Maricopa County is presented by the Law Library Resource Center, which is part of the Superior Court of Arizona in Maricopa County. Links to forms, packets, and other resources are available in the video description below. Here's what this video covers: the divorce and legal separation process in Maricopa County from beginning to end, what packets and forms you might need, the difference between community property and debt and separate property and debt, how spousal maintenance and child support is determined, what legal decision-making is and how it's decided, and finally, what parenting time is and how it is decided. This flowchart gives you a basic view of the divorce and legal separation process and is available as part of the step-by-step guide. See the description for links to the guide. All of our forms are grouped into packets and steps, and each process is a packet of forms, instructions, and procedures. You'll usually need every form in a packet, but there are some packets where you might not need everything. It depends on your situation. For example, there are different forms for cases with children and cases without children. And there are even different settlement events for cases with and without children, but otherwise the process is the same. See the video description for links to these packets. And here are the requirements to file for divorce or legal separation in Arizona. Number 1, to file for divorce, at least one of the parties must have lived in Arizona for 90 days prior to filing. If either party is in the military, this can include being stationed here for those 90 days. But if the other party has never been to the state, the court may not have the authority to make orders. And to file for legal separation, at least one of the parties must either live or be stationed here at the time of filing. Number 2, if you have minor children, they must have lived in Arizona for the last 6 months prior to the filing. If they're younger than 6 months, they must have lived here since birth. Also, Arizona has a covenant marriage option. But if you don't know what a covenant marriage is, you probably don't have one. You would have gone through counseling and have made a specific request on your marriage license to have a covenant marriage. We don't have forms specifically for covenant marriage. You may be able to use some of the forms, like the summons or the preliminary injunction, but you can't use our petitions or decrees. If you do have a covenant marriage, you may want to talk with an attorney for help with that divorce process. And here's an answer to a common question. You do not have to file for legal separation in order to get a divorce. Many people file for legal separation for religious or personal reasons. Legal separation will still divide all property and debts, award support, and establish parenting time, just like a divorce. The only difference between legal separation and divorce is that with legal separation, the parties are still legally married and cannot remarry. What you're seeing now are the basics of the divorce process in Arizona. In the first step, one party files to start the case. That person is called the petitioner or Party A. In step 2, the petitioner arranges for the other party to be served the papers. The other party is called the respondent or Party B. In step 3, the respondent has a limited amount of time to disagree and file a written response. If they want to file a response, the paperwork can be found under step 3. And here's an important thing for both parties to know. It's not necessary to file a response unless the responding party wants to disagree. It costs money for them to file, and there's no need for the other party to respond and pay a fee if they agree with everything requested in the Step 1 papers. If the responding party does not file a response, then the petitioner can apply to enter their default. This means that the petitioner can proceed without any input from the respondent, and it's assumed that the respondent agrees with everything. If no response is filed, then Step 3 becomes the default application, and Step 4 is the default decree. You can submit the Step 4 default decree by hearing or by motion. Also, it's important to know that Arizona has a mandatory 60-day cooling-off period. This means the court cannot enter a divorce or legal separation decree any sooner than 60 days from when the respondent was served. There's nothing you can do to change this. The 60-day period applies even if both parties agree. If a response is filed, the court will schedule a settlement event like a resolution conference. Once the response is filed, it's time to complete disclosure and discovery. Disclosure is a requirement to voluntarily share information with the other party. We have a disclosure statement form on our website. Discovery is how you formally ask for documents, evidence, and any other information from the other party and any third parties. This includes things like interrogatories, requests for production of documents, and subpoenas. If all settlement attempts are not successful, the court will set a trial date for unresolved issues. In this example, Step 4 is the decree. If there is a trial, the judge makes orders and issues the decree. But if the parties reach a full agreement before or during the trial, they can still sign a consent decree. If you and the other party reach a full agreement after the initial papers are filed, you can use the consent decree packet. This is in Step 4. The responding party does not have to file a written response, but will have to make an appearance by paying the response fee. The Step 4 consent decree packet includes all the information for the final step. Both parties must complete and sign the consent decree. If any minor children are involved, there are additional forms to submit. And as a reminder, the 60-day waiting period still applies. So, there's a newer process authorized by statute when parties have reached a full agreement before filing. This is called the summary consent decree process. If you both agree on all aspects of the divorce, this may be the simplest and quickest method. All the forms and instructions are together in one packet, and you can file and submit all of the forms in one day. But please be sure to read the instructions and follow all the necessary steps. Both parties will pay a fee at the time of filing. Always check the Clerk of Superior Court's website for current fees. However, the court will still wait at least 60 days from the date of filing to review and sign the consent decree. We also have forms to withdraw from the process, but they must be filed before the 60 days are up. This process uses many of the same forms we're discussing in this video, but we won't discuss forms that are unique to this process. The packet has detailed instructions and procedures. Read those procedures carefully to determine the number of copies you'll need of each document, how to file those forms, and how to submit the decree. Okay, here's some important information on filling out court forms. When printing and saving court forms, all documents must be one-sided. This is because they're scanned and saved electronically, and anything on the back will not be scanned or filed with the court. All our forms are fillable PDF files, and they can be typed. While they don't require it, judges prefer typed forms, and it's highly recommended that you type your responses. But if you do handwrite them, your writing must be printed and legible, no cursive writing. Also, you can only use black ink. And one more thing about filling out forms: do not leave blanks. If something doesn't apply to your situation, just cross it out. Write NA for not applicable or put unknown. When you file your first papers, the filing fee is due. Always check the Clerk of Superior Court's website for current fees, as they are subject to change. Also, you can submit a fee deferral application to ask to waive or defer the fee. A waiver means the fees will not be owed at all. But this is only available in limited situations where you have no earned income and may be receiving certain types of government assistance. Deferral means you will owe the fee later. You may have to pay part of it now and part of it at the end, or you may be able to pay all of it at the end. You might also receive a payment plan. Most people qualify for some kind of plan. If your fee is deferred, there will be a one-time charge of approximately $35 added on. The parties starting the case can use the online fee deferral application portal as long as you do not have a case number yet. You can find the link to the fee deferral application in the video description. The following forms are required for divorce and legal separation, either with or without minor children. The Sensitive Data Cover Sheet is a form that provides information for the Clerk of Superior Court. The summons tells someone they're being sued for divorce or legal separation, and it tells them what to do to prevent default orders. This form is not used in the summary consent decree processes. The preliminary injunction is an immediate court order that applies to both parties. The petition tells the court what you're asking for. And there are also 2 notices, but I'll review those and the other forms in more detail later. And this list of forms are those required in cases with minor children. The parenting plan tells the court what you want to do about legal decision-making and parenting time. And as for these other forms, I'll get into their details a little later. Now we're going to go over what's called the Family Department Sensitive Data Cover Sheet. This document is confidential and not available to the public. It's not served on the other party. It's only information for the court. And here's a very important tip. For each of these forms, you must always complete the case caption. The case caption is where you record the information about the person filing. It's located in the upper left-hand corner of the first page on each form. The case caption must include your name and address, unless you've asked to have it protected by the court, and your phone number. You'll also need to include your email address if you want to be contacted that way. And if you're representing yourself without a lawyer, make sure you check this first box. The case caption also includes the party designations. Enter the name of the petitioner, or Party A, and the name of the respondent, or Party B. These designations will never change. If you are the petitioner, you'll always be the petitioner, even if the other party later files to modify the orders. Unless you already have a case number from a child support case, the clerk will assign a new number when you file to start the case. And here we have the summons. The summons is a notice to the respondent that they're a party in a court case. It tells them what happens if they take no action, and it explains how long they have to take action. We'll talk more about the summons in a little bit. The preliminary injunction is an immediate order to both parties once the respondent is served. It tells parties with children that they cannot travel out of state without permission from the judge or the other party. It tells the parties they cannot move, hide, or sell assets. It also tells both parties that they can't remove the other party or kids from health plans. However, this is not required in legal separation cases. It's an order that can be enforced and is effective until the court makes the final orders, which is called the decree. This form is a notice, and it tells parties their rights regarding health insurance and the availability of continued coverage through COBRA. It must be completed, filed, and served on the other party. This notice is not required in legal separation cases. The notice regarding creditors informs both parties about their responsibility related to community debt. Regardless of whose name is on it, any debt obtained during a marriage may be considered community debt. The complete form can be used to request a credit report of your spouse to learn of any possible unknown community debts. This form is required, but only the first page is filed. However, all pages are served on the other party. And this page is the petition. The petition is the main form that provides information to the judge and the other party. It also tells the judge and the other party how you want to divide the property and debts, handle issues regarding the children, and decide spousal maintenance and child support. If the other party files a response, the response form provides similar information. In the petition, certain questions must be true for the case to proceed. If you miss these boxes, the court might dismiss your case or require you to file an amended petition and restart the whole process. As we said before, our petition form cannot be used for a covenant marriage. And while Arizona is a no-fault state, if the parties do not agree that the marriage is irretrievably broken, the judge must hold a hearing and make a finding. To petition the court for divorce or legal separation, you must believe that the marriage is irretrievably broken. The last question here is only for cases with children. It must be true and be checked for this court to make orders concerning children. Both of these statements must be true to proceed. Venues means that this is the proper court to file the case. Either one or both parties or the minor children must live in Maricopa County to file in our court. This box must be checked, and the statement must be true. The 90-day requirement means that in order for Arizona to have authority to hear the case, either one or both parties must have lived or been stationed in Arizona for the last 90 days. You must check at least one of the boxes or your case may be dismissed. However, the 90-day requirement does not apply to legal separation cases. It only requires that one party currently live or be stationed in Arizona. The petition and response provide a party's request to the court. Or in other words, they tell the judge what orders each party wants the judge to make. They tell the court about your family, property, and debt, and what orders you want. If you don't include property in your petition or response, you may not be able to include it in your decree, especially if you proceed by default. If your decree doesn't have property listed, you won't be able to add it later. And if you don't ask for spousal maintenance now, you can't ask for it later either. If either party has a retirement account, any money earned during the marriage is considered community property. You'll need a court order to divide that retirement account, even if one party is keeping all the money. This order is called the Quadro, or QDRO, which means Qualified Domestic Relations Order. If you don't include retirement accounts in the decree, you won't be able to add them later. This can also make it difficult to get that money when you retire. Let's go over property. There are basically two kinds of property. Real property includes things like land, houses, condos, townhomes, and commercial property, whether it's owned or mortgaged. It does not include a place you're renting. Personal property is everything else. Personal property can include things like cars, trailers, and RVs, retirement accounts, bank accounts, investment accounts, household furnishings, jewelry, and more. While we're talking about property, let's go over community property. Arizona laws are defined in our statutes. These are called Arizona Revised Statutes, or ARS. Community property is defined in ARS Section 25, subsection 211. Generally, all property acquired during a marriage is considered community property. It doesn't matter if only one party's name is on the title. If it was property you owned before marriage, like a home, but you paid a mortgage or for repairs during the marriage, the community, which means both you and your spouse, would have a reimbursable interest in the property. If you've already divided up personal property, you can write in the community property section that the parties will keep tangible personal property already in their possession. Separate property is defined under ARS Section 25, subsection 213. Separate property includes property owned before marriage, such as a house or a car. It also includes property acquired during the marriage by gift or inheritance to only one of the parties. The increase in value, rent, and profits from separate property are separate property. However, keep in mind that money and time put into maintaining, fixing, and enhancing separate property during the marriage may give the community a reimbursable interest in a separate property. Okay, on to community debt. Community debt is determined in the same way as community property. Generally, it includes all debt acquired by either party during the marriage, like a mortgage, medical debt, student loans, credit card debt, car loans, etc. It doesn't matter if only one party's name is on the loan. And separate debt is determined like separate property. Generally, debt acquired before the marriage, such as a mortgage, student loans, and car loans, will remain separate debt. However, the community may be entitled to reimbursement for payments made during the marriage. All right, we are moving on to spousal maintenance. Spousal maintenance is covered by ARS Section 25, subsection 319. A judge must make their decision based on statutory factors that are listed in the statute and on our form. A change in the law in September of 2022 directed the Arizona Supreme Court to establish guidelines. There are several specific criteria that must be considered. These include things like the length of the marriage, age and earning ability, financial resources, and many others. The court must follow the guidelines when determining the amount and length of spousal maintenance. They can order it only for a period of time and in an amount necessary to enable the receiving spouse to become self-sufficient. Now, there is an exception if the court finds the guidelines are inappropriate or unjust. But you must identify which factors apply to your case on your petition or response. The judge will decide whether they apply and then use the guidelines to determine how much and how long to order it. The guidelines apply a specific formula in an online spousal maintenance calculator. You can see the link to it on your screen, and it is also provided in the packet. There are situations where you are required to prepare and file the worksheet, and we will discuss this later. You can find the link to the spousal maintenance calculator in the video description. Child support is determined by the Arizona Child Support Guidelines. This is a formula that considers many things, including the income of both parents, the parenting time arrangement, whether there are other minor children either party supports, and any extraordinary expenses related to the children. The court may approve a request to deviate from the guideline amount. This means they order an amount different than the guideline, including a $0 order. The judge must consider the best interest of the child when deviating. You have to complete a child support worksheet. This form is not in the packet because the court wants you to use the online child support calculator. You'll find the link to the calculator in the video description. The calculator will also create a child support order and an employer information sheet. Both are required with your decree. You must complete the worksheet with your petition so you know how much to ask for. You'll also have to do it later during settlement in preparation for trial and with your default or consent decree. The court has to make orders for the child support, even if the amount is $0. Legal decision-making is what we used to call custody. It's about who makes the major decisions regarding school, religion, medical issues, etc. It's based on the best interests of the child, which considers many factors listed in the statute. Sole legal decision-making does not mean one party has parenting time and the other does not, and it doesn't give a parent the right to change a parenting plan. For example, one party can have sole legal decision-making and the parties still share parenting time equally. Parenting time is also about where the children will live and when. The law requires reasonable parenting time that is substantial, frequent, meaningful, and continuing contact. Exceptions are made if a court finds after a hearing that parenting time would endanger the child's physical, mental, moral, or emotional health. If you believe reasonable, unrestricted parenting time would endanger the child, you may ask that the other parent's time with the child be supervised or restricted. And in an extreme situation, you can ask for no parenting time at all. If you do ask to impose conditions on the other parent's time or for no parenting time at all, you'll have to provide an explanation as to why this is in the best interest of the child. Parenting time is also detailed in a parenting plan. The parenting plan is where you tell the court what orders you want for legal decision-making and parenting time. This includes time for the school year, holidays, vacations, phone and email contacts, and other restrictions or limitations. When you submit this with the petition, it only requires the signature of the person filing, even if you believe the other party agrees. If both parties agree on all terms of the parenting plan, space is provided for the other party to sign. And if you're submitting a parenting plan with a consent decree, both parents must sign it. The affidavit regarding minor children is required by federal law. It's designed to help determine if this is the proper court to decide issues regarding children. The form details where the children have lived over the last 5 years and asks about other cases in Arizona or any other states. The questions include cases regarding legal decision-making and parenting time, dependency cases such as those filed by the Department of Child Safety, protective order cases, and non-custody cases like car accidents. It also asks whether there's anyone who might claim third-party rights, like a grandparent who's been taking care of the children. Now we're going to discuss the PIT class. Arizona requires parents involved in a family court case to complete the Parent Information Program, also called the PIT class. It's a roughly 4-hour program on how to work with the other parent in the best interest of the children. There is a fee for the class, but the cost depends on the class provider. You can also apply for a fee deferral or waiver. The classes are in English and Spanish and may be available in other languages. They're available online and in person, and once completed, the course provider will transmit the certificate of completion directly to the court. The PIMP order and notice orders both parents to take the class and lists contact information for the class providers. All pages, not just the front page of the notice, must be filed and served on the other party. A parent who does not file a response or complete the class may still be granted parenting time. However, the court will not consider a future request from that parent to change or enforce the order until they complete the class. If either parent finished the class for another family court case, they may not have to retake it. They can submit a motion to ask a court to accept the other class. It's also important to know that if you're attending the program in person, the parents are not allowed to attend together. All right, now we'll go over how to file. Once you've filled out all the forms, you'll need to make copies and file them with the court. You can file in person, or you can file online using EFile. We'll go over EFiling in a moment. If you're filing in person, make 2 copies of everything except the cover sheet. The original is for the court. 1 copy is for you, and 1 copy is for the other party. If the Division of Child Support Services is involved in your child support case, you'll also need to make an extra copy for them. Next, file all the documents, including the cover sheet, with the Clerk of Superior Court. There are 4 clerk locations where you can file. 1 in downtown Phoenix, 1 in North Phoenix, 1 in Surprise, and 1 in Mesa. The clerk will keep the originals and return all the copies to you. Also, it's important to note that you must pay the full fee or turn in the fee deferral application when you file. As long as you don't have a case number yet, you can apply online for a fee deferral before you file your first papers. Again, the link is available in the video description below. If you decide to e-file your forms, please read the e-filing instructions first. There's an additional processing fee for each document that's charged by the e-filing provider, not by the court. You can pay the fee online or complete the online fee deferral application first. You can find the link to the e-file instructions below. Also, the e-filing program creates many of the documents in the first step, so you don't need to complete the paper versions of those forms. Once the documents are submitted and accepted, you'll need to print at least 1 of each document. You can only serve paper copies of the forms on the other party. You can find the link to begin the e-file process in the video description. It's also important to note that you cannot e-file the forms for the summary consent decree process at this time. So once you've filed your forms, the next step is to arrange to have them served on the other party. Information and forms for this part are in our Step 2 service packet. There are a few different ways to properly serve the other party. The acceptance of service method is generally the cheapest, and if you work well together, this might be the best option. You'll need to mail or simply hand a copy of the papers and an acceptance of service form to the other party. They must sign it in front of a court clerk or notary. Then you have to make sure that the form is filed with the court. Service is not effective until the acceptance form is filed. We recommend that you fill out the form for the other party, except for the signature, to be sure all the needed boxes are checked. Signature confirmation is the next cheapest method. You can use the United States Postal Service or any national delivery service like UPS or FedEx, but it must be sent with restricted delivery and signature confirmation. This means you'll get back the other party's signed signature card to file with the court. That signed card must be attached to and filed with the form called Affidavit of Service by Signature Confirmation. Service is considered effective when the delivery is signed for by the other party. If neither of these options will work or the other party refuses to sign, you'll have to hire a process server. Private process servers must be registered with the state. To find one, you can do a search online or go to the azcourts.gov website for a list. The Maricopa County Sheriff's Office also provides service. They have civil service offices at the downtown and North Phoenix court buildings. If the other party needs to be served in another state, the process server must comply with that state's laws. The process server should return an original or filed affidavit or declaration of service form. But it's important to note that if they give you the original, you must go to the court and file it. Service is considered effective on the date the documents are served to the other party. Now, if the other party lives in another country, service is a little more complicated. In this case, you'll have to serve them under international law. There are special rules for international service. Each country has their own process, and many countries are party to an international treaty. You can find some information on the U.S. State Department's website, which is available in the video description. Because serving someone in another country can get very complicated, we recommend that you talk to an attorney for help. Also, you must make reasonable efforts to locate and serve the other party. This includes things like mailing to their last known address, calling them, contacting family, friends, or employers, reaching out on social media, emailing, and texting. If you tried and still can't locate the other party, you can file a motion with the court asking to use an alternative form of service. The forms and instructions for this are in our Step 2 service packet. But remember, you must wait for a judge to grant or deny your motion for alternative service before you try it. Once the other party has been served, you'll have to wait and see if they file a response. Generally, they'll have 20 days to respond if they're served in Arizona and 30 days to respond if they're served outside of Arizona. More time is required if they're served by publication or another alternative service. For example, if they're served by publication in Arizona, they have 50 days to respond from the date of first publication. But if they're served by publication outside of Arizona, they have 60 days from the date of first publication to respond. Some of you are probably wondering, what happens if the other party doesn't respond? So, if the other party does not file a response, you can proceed with what's called the default process. The first thing you need to do is complete the application and affidavit for default. This is in the Step 3 default packet. If you've requested spousal maintenance, there's a second form in the packet you'll have to complete. If the other party's default is entered, the next part of the process is the Step 4 default decree. On the application and affidavit for default form, you must check boxes in each section. If you miss any sections, you'll have to redo this step. If the other party is an active member of the military, you must have a signed and filed Service Members Civil Relief Act waiver. This form is not in the packet, but it is available on our website. On the application, you need to list the respondent's address, or at least their last known address. You must also attach the proof of service, or check the boxes to indicate that the proof is already filed in the court record, and also provide the date and method of service. Proof of service can include the acceptance of service, the affidavit regarding signature confirmation, or the declaration of service. You also need to mail a filed copy of the application and any attachments to the other party the same day that you file it with the court. If the petitioner requested spousal maintenance, the default information for spousal maintenance form must be completed. It details the party's finances and income. If you plan to complete your final step by motion, meaning you will not request a hearing, you must also submit a completed spousal maintenance worksheet, along with the application for entry of default and the default information for spousal maintenance forms. They are filed at the same time as the application for default. A filed copy must also be mailed to the other party. After filing the application and affidavit for entry of default, you must wait 10 business days. If the respondent does not file a response, you can proceed with the final step, the default decree. You'll have to wait 60 days from the date of service or 10 business days from the date you file the application for default, whichever is later. You can then proceed by hearing or by motion. It's recommended you complete the checklist provided in the Step 3 default application packet to determine if you are ready for Step 4, the court order. Step 4 in the default process is the default decree. There are two ways to go about this, by having a hearing or by motion, which means there is no hearing. Default decree hearings are held either online or by phone. You must have a hearing if the other party was served by publication, is a minor, or incompetent. You must also have a hearing if you're asking for a decree that is different from your petition, or for amounts greater than requested in the petition, unless you have a written separation agreement. To have a default hearing, you'll first need to submit your proposed forms to Family Administration for review. You have to wait 60 days from the date the other party was served or 10 court days after filing the application for default in Step 3, whichever is later. Once the appropriate amount of time has passed, you can submit your proposed forms by email or by delivering them to the Family Department at any Superior Court location. As mentioned, in order to get your default decree by hearing, you must first submit a packet of completed forms to Family Administration. Be sure you've filled out the decree correctly. Use your petition to help you fill out the decree, and remember, your decree cannot be different from your petition. And if you've requested spousal maintenance, submit your completed spousal maintenance worksheet. You must also provide either a copy of your receipt for payment of your filing fee or the order regarding deferral of waiver of court fees and costs. If you have minor children, you must also submit the parenting plan, child support worksheet, and child support order. If you're asking that child support be withheld from the paying party's paycheck, you must also submit a current employer information sheet. You must also provide information to support the child support order. This includes income information such as pay stubs for both parties, information about child care expenses, insurance premiums, and any special education or medical needs of a child. Lastly, be sure to file the certification of attendance from the Parent Information Program class. As we mentioned, in order to get your default decree by hearing, you must first submit a packet of completed forms to Family Administration. Be sure you've filled out the decree correctly. Your decree cannot be different from your petition. Use your petition to help you fill out the decree. If you have minor children, you'll also need to complete and turn in the parenting plan, education order, child support worksheet, and child support order. Here's what you need to deliver: 3 copies of the decree, and 3 copies of the other forms if applicable. If you want to proceed by motion, which again means without a hearing, you must also complete the form called Motion and Affidavit for Default Decree Without a Hearing, which is in the Step 4 packet. Fill out and prepare 3 sets of the decree. If you have minor children, you'll need to do the same with those forms. Next, wait until it's been 60 days from service or 10 court days after filing for default, whichever is later. When the time is up, file the original and at least 1 copy of the motion with the court. When all of that's done, prepare a package for the judge that includes 1 filed copy of the motion, 3 sets of the decree and other forms, if applicable, 1 set of documents for child support, such as pay stubs, childcare, and insurance information, and 2 stamped and addressed envelopes, 1 addressed to you and 1 addressed to the other party. Then, deliver that package to the judge's inbox. Next, the judge reviews the documents. If the documents are okay, the judge will sign, file, and mail copies to you and the other party. But if there are any issues, the judge will reject the package and return it to you with a memo explaining what's wrong. You can then fix those issues and submit the package again, but you'll need to complete and file a new motion. If you keep having issues, we recommend scheduling a hearing where the judge may be able to help in more detail. So, a trial can happen if a response is filed and the parties can't come to an agreement. When the response is filed, the court will schedule a resolution conference. This is also the time for disclosure and discovery. Disclosure is a requirement to voluntarily share information with the other party. Initial disclosure is due no later than 40 days after the filing of the response. Discovery is how you formally request documents, evidence, and information from the other party and any third parties. Discovery also includes depositions and things like interrogatories, requests to produce documents, and subpoenas. A resolution statement is usually due 30 days after initial disclosure, or whenever the judge says. The court will likely schedule court mediation for legal decision-making and parenting time issues, but parties can choose to attend private mediation for any and all issues, including child support. If there is no settlement at the resolution conference or mediation, the court will schedule a settlement conference and a pretrial conference. A pretrial statement is required if a pretrial hearing is scheduled. If settlement attempts are not successful, the court will set a trial date for all unresolved issues. Also, the parties can sign and submit a consent decree at any time after the 60 days from service of the petition. If the responding party has not paid the response or appearance fee, they'll have to pay it at that point. Remember to check for the most current fee, as they are subject to change. If you come to an agreement, you must complete the consent decree. If the parties are requesting an order for spousal maintenance, you must also prepare a spousal maintenance worksheet using the spousal maintenance calculator. This must be submitted with your proposed consent decree. You must also complete the notice of lodging. And if you have minor children, you'll need to complete the parenting plan, child support worksheet, and the child support order. It's also important to know that notarized signatures are required, or both parties can sign in front of the clerk of court. First, fill out the notice of lodging and make a copy. Then, attach a copy of the consent decree to the original notice of lodging. If applicable, you'll also need to attach the spousal maintenance worksheet. And if you have minor children, you'll need to attach a copy of the completed parenting plan, child support worksheet, and child support order. Next, file the original notice of lodging and attachments. Then, you'll also file a copy of the notice of lodging without attachments. Then, prepare a package for the judge. It needs to include the filed copy of the notice of lodging, one original and 2 copies of all forms, including the decree and forms for cases with minor children, a copy of the receipt of payment for both parties filing fees, and a pre-addressed stamped envelope for each party. When the package is complete, deliver it to the judge's box. The judge will then review it. If anything's missing, they'll reject it and return the package to you with a memo of the issues so you can submit it again. But if everything looks good, they'll sign and return the copies to each party in the envelopes you've provided. Here are a couple of tips and reminders. Whatever packet or form you're working with, be sure to read through it before you start filling it out. Instructions, steps, and procedures, including the links, phone numbers, and other information, are included in the packets and are also available in the video description. Finally, here are some resources that the Law Library Resource Center offers. The Law Library is open Monday through Friday from 8 a.m. to 5 p.m. We're available in person, by phone, by email, and by live chat on our website. The Law Library also offers several services to help you with court forms and court navigation. You can attend an online workshop that features a live question and answer session at the end. Topics include divorce, modification of child support, sealing of criminal records, and more. Appointments for a 15-minute forms review are available. You can ask questions about your court forms or have them reviewed for blanks and missing information. However, to use the service, you must have completed your forms to the best of your ability. The Family Forms Clinic brings Arizona Legal Center attorneys and ASU law students to the Law Library to help you fill out family court forms. And a Lawyers in the Library program offers free 15-minute appointments for legal advice. This service is only available in person, with same-day in-person sign-up. If you're interested in any of these services or events, please visit the Law Library Resource Center events calendar for dates, times, and scheduling information. And while the Law Library can't offer legal advice, there are many free and low-cost options available. Community Legal Services is the local legal aid. You have to qualify based on income, and they only handle family matters when domestic violence is involved. The Free Legal Answers site is only available online. You submit your questions and an attorney will respond. You have to qualify based on your income, however. The Family Lawyers Assistance Project is volunteer attorneys offering free 30-minute appointments by phone to those who qualify based on income. You can use the library's Unbundled Limited Attorney Services list to hire attorneys for piecemeal work. You pay only for the services you need. The Maricopa County Lawyer Referral Service refers you to an attorney for a $50 half-hour appointment. And the State Bar of Arizona Member Services site is a directory of all the attorneys in the state. Please check the description below for links and other resources.